Let's look at your testimony in the jam poll case, sir. And you remember the attorney in that case asked you a lot of questions, just like I am right now, about who asked you to prepare the report. You've been asked that by a lot of lawyers at a lot of depositions, haven't you?
Yes, I have.
Okay. In this particular case, this is again the jam poll deposition taken on March 5th, 1986. And I'll direct your attention to page 50. Page 50, lines 12 through 23. Take a look at your testimony in that case and see if that refreshes your recollection, sir.
This seems to state the same thing I've stated here today.
Okay. Well, let's make sure that it does, because I want to make sure the jury understands what your position is, sir. You don't know one way or the other whether anybody asked you to write this value analysis, which has been marked as Exhibit 4, do you?
Repetitive and argumentative.
I state again, I don't recall anyone asking me to write this report, and I don't believe anyone did.
But that doesn't answer the question, sir. You don't know one way or the other whether someone asked you to write the report, do you?
Repetitive and argumentative.
I've told you what I remember.
Okay, well then let's look at your prior testimony, sir. Do you remember these questions and these answers being given back in the jam poll case when you were under oath and sworn to tell the truth back in March 5th of 1986? Question, on page 50, line 11, you just don't remember one way or the other. Answer, I do not remember anyone asking me to prepare this. Question, are you saying that no one asked you to prepare it, or you don't have a memory one way or the other, sir? Your answer was, either would apply. Question, well, are you just simply saying, sir, you don't have any memory of the matter? Your answer was, I do not recall anyone asking me, and I do not know if anyone did ask me. Question, they might have and they might not have. Answer, as I said, I don't remember. Was that your testimony under oath back on that date, sir?
No predicate
Yes.
established, improper impeachment.
And isn't it true that you don't know one way or the other, you don't remember whether anyone asked you to write this value analysis or to do this value analysis marked as Exhibit 4?
Repetitive.
You don't remember, do you?
Repetitive and argumentative.
All I can tell you is I remember lots of things, but I do not remember anyone asking me to write this document, and I don't believe anyone did.
Okay, but it's possible someone asked you to write it and you just don't remember it. Isn't that true?
I'm not going to
Speculative,
speculate.
ask and
Yeah,
answer.
you're not going to speculate, Mr. Ivey, because you have total memory failure when it comes to this document, don't you?
No, I do not.
Argumentative.
You don't have total memory failure.
Argumentative.
Who asked you to write it, sir?
I don't
Argumentative.
remember.
Did you do it on your own?
Hold it. Slow down. The court reporter can't get everything down. Mr. Kelley and Mr. Ivey, slow down a little bit. Let's get some separation for the court reporter. I'm going to put my objections on the record. The last question was argumentative, repetitive, asked and answered.
Okay. The fact of the matter is, sir, when you were asked under oath on this other occasion, when you were telling the truth back then, your testimony was you didn't recall one way or the other whether anyone asked you to write that value analysis memo. Isn't that true?
Argumentative and repetitive.
I can only state this is what I stated back then. I don't recall anyone asking me, and I do not know if anyone did ask me. That's what's stated.
Right. You don't know if someone asked you, do you?
Argumentative and repetitive.
I said I do not remember anyone asking me. I've also told you I don't believe anyone did.
But you don't remember whether someone asked you. Isn't that what that says?
Argumentative and repetitive.
All I said is I don't remember.
If anyone asked you to write it, correct?
Argumentative and repetitive.
In referring to this, that's what I said back then.
Okay. And that was the truth, wasn't it?
Having a truth of what I remember is all I can state here.
Was that the truth, sir? When you gave that sworn testimony to those lawyers under oath back on that date, was that the truth?
Argumentative and repetitive. Mr. Kelley, you don't have a right to yell at any witness.
I'm not yelling. I want to know what the truth is.
What I stated back then was the truth when I said it now. Today, what I remember, I don't remember anyone asking me to write this report.
Right.
I could speculate, and I choose not to. That is an opinion, a speculation, and is not truth or not.
Truth or not?
Telling you the truth, I do not remember anyone asking me to write this report, and I'm also telling you I don't believe anyone asked me to.
Well, that's your testimony today, isn't it?
Argumentative.
But that wasn't your testimony back in 1992, was it?
Argumentative.
Well, actually, this is 1986.
Argumentative.
That wasn't your testimony back then, was it?
Argumentative and repetitive.
When I read the testimony, it sounds like I'm saying the same thing.
Okay. Your testimony back in 1986, sir, was, I do not recall anyone asking me, and I do not know if anyone did ask me. Question, they might have and they might not have. Answer, as I said, I don't remember. That was the truth, wasn't it?
Argumentative and repetitive. Mr. Kelley, you are way overstaying your welcome on those lines. You have asked that 8 or 9 times now. That's enough. Now move on.
I'm not going to say today that I was not telling the truth back then. What I stated then was what I stated now. I don't remember.
Okay. You don't remember. That is the truth, isn't it?
I don't remember anyone
repetitive.
asking me to write this report.
Okay. And you don't remember if anyone did ask you to write the report. True?
I
Argumentative
don't
and repetitive.
care to speculate on that.
Okay. Because if someone did ask you to write this report, then the next question would be, who, Mr. Ivey, who asked you to write the report? Wouldn't that be the next question?
Argumentative.
I don't know what question you ask. You're asking the questions.
Okay. Now, this value analysis that's been marked as Exhibit 4, sir, you did that, and it was because you were involved in the study of the performance of passenger cars in rear impacts. True?
Objection, like a predicate.
I don't know why I wrote this report.
Well, was the value analysis done, sir, because you were involved in the study of the performance of passenger cars in rear impacts?
I don't remember, and anything else I tell you would be speculation.
Okay. You know that this litigation that you're being deposed in today involves the rear impact to an automobile, don't you?
Objection, that...
Yes, I do.
Okay. And the value analysis memorandum was done as a result of your study of the performance of passenger cars in rear impacts. Isn't that true?
Objection.
I've stated innumerable times today, I don't remember why I wrote it, and I don't know that it relates to my studies that I've done before.
You don't know that whether, as you sit here today, whether that value analysis memo involves or arose out of the study of the performance of passenger cars in rear impacts. Is that your testimony under oath before the jury?
That's asked and answered, repetitive and argumentative.
That's my answer.
That's your testimony, your truthful testimony?
Yes.
Argumentative and repetitive.
Well, then let's take a look at the affidavit that you filed in the Mosley case, sir. Could you give me a stapler over there? There's one sitting back over there. Do you remember filing an affidavit in the Mosley case, sir?
Yes, I do.
Do you remember the facts of the Mosley case?
Yes.
What happened to Shannon Mosley in that case, sir?
Objection.
I believe he died.
He burned alive in a General Motors truck, didn't he?
Objection.
I don't know. I believe that's the case, yes.
And Mr. Butler, who was the lawyer who represented the Mosley family, took your deposition in that case, didn't he?
Yes, he did.
And you, at the request of General Motors legal staff, prepared an affidavit in that case, didn't you?
Yes.
And do you remember, sir, stating in that affidavit that your value analysis report that's been marked as Exhibit 4 involved the study of the performance of passenger cars in rear impacts?
I don't recall the details of the affidavit.
If you did do that affidavit at the request of the legal staff, would that have been the truth?
Yes.
Okay. Well, let me show you your affidavit, sir, and tell me if that was not your truthful testimony back on that date.
Yes.
So your analysis, sir, marked as Exhibit 4, involved the study of rear impacts to passenger cars, didn't it?
Yes, although the report itself doesn't state that.
But now we've gotten to the truth, haven't we? That's what it involved, didn't it?
Argumentative, repetitive.
The analysis that I did relates to fuel-fed fires in automobiles and not in pickup trucks. And that's why it's stated
Automobiles
this way.
and rear impacts, correct?
My analysis here says nothing about rear impacts.
How about your affidavit that was filed in the Mosley case? Does it talk about rear impacts?
Yes, it does.
Now, the real reason you filed that affidavit was because you wanted to keep the plaintiff's lawyer from being able to show that value analysis to the jury in the Mosley case. Isn't that true? Isn't that the reason you signed that affidavit?
Objection, speculative, objection to the
The
form.
reason this affidavit was done was to point out the fact that this study related to cars and not trucks.
Not pickup trucks.
That's correct.
Because in that case, the lawyer wanted to show the jury your value analysis, didn't he?
I have no idea what Mr. Butler wanted to do.
You have no idea that Mr. Butler wanted to show the jury and get that into evidence, your value analysis, so that the jury could see what General Motors was considering?
That's speculative about what Mr. Butler thought.
I have no way of knowing.
Well, you
Mr.
sat down
Butler
with
wants to
legal
do.
staff and prepared that affidavit, didn't you?
That's true.
And who were the lawyers that helped you prepare that affidavit, sir?
Objection, don't answer that question, that's privileged.
It was GM legal staff that helped you prepare that affidavit, wasn't it?
Objection, don't answer that question.
He's
that's
already answered the
privileged.
question.
Well, then it's repetitive, don't answer it again.
Okay. That deposition was prepared in an office, wasn't it?
I don't recall the details of it.
You don't recall the
Preparing this
details of
affidavit.
preparing that affidavit? Did you
No.
type it up, or did General Motors legal staff type it up?
I don't remember who typed it up.
Did you type it up?
No, I did not.
Can you type?
Yes.
You can type. How long have you been able to type, sir?
Since I was in
That's
high school.
argumentative.
Since you were in high school, you could do your own typing. Is that right?
That's correct.
Argumentative.
Okay. Did you type that affidavit that's in front of you?
No, I did not.
Who typed it?
I don't remember.
Where were you when you signed it?
I don't remember that either.
Were you with GM lawyers when you signed that affidavit?
As best I can recall, yes.
Okay. Now, when you say that your value analysis report marked as Exhibit 4 involved the study of the performance of passenger cars in rear impacts, what are you referring to there? When you say in this affidavit, my analysis involved the study of the performance of passenger cars in rear impacts, what are you referring to?
I guess I don't understand the
Well,
question.
the reason I asked the question is the summer 1973, when you prepared this value analysis report, is also the same summer that you did the junkyard survey with Mr. Muddy, and is also the same summer that you analyzed all the pending lawsuits against General Motors, right?
That's correct.
And the lawsuits that you analyzed pending against General Motors, you told us earlier, were lawsuits arising out of rear impacts, correct?
That's
Objection.
correct.
So is that what you're referring to? Is that the value analysis involved the study of the performance of passenger cars in rear impacts, are you referring to the analysis that you had done of the litigation that was pending against General Motors?
I don't remember. That's what's stated there. This analysis makes no reference to rear impacts.
Well, I understand that, but your affidavit says that that's what you were considering was rear impacts. And so my question is, did you base it on the information that you learned in looking at the pending lawsuits against General Motors at that time?
I don't believe so.
But you don't know.
I don't remember, as I stated many times, why I wrote this analysis.
Right. You don't remember who asked you, or if you were asked, or why you did it.
I don't.
That's your testimony, isn't it?
Paul, if that is repetitive, don't answer that question again. You've answered it about 11 times. That's enough.
Read back the question, please.
You don't remember who asked you or if you were asked or why you did it. That's your testimony, isn't it?
Do not answer that question. That has been asked over and over and over again.
Mr. Gerber,
Don't give me the attorney's fees speech. You know you have some obligations under your oath as an attorney to stop badgering and being repetitive. You have asked that. That's it.
I'm not going to give you the attorney's fees speech because it is abundantly clear from the history of litigation of lawyers against General Motors that General Motors doesn't give two hoots about paying attorney's fees. They'll pay hundreds of thousands of dollars in sanctions and attorney's fees
And so will Jim Butler.
before they will disclose documents. Okay, so I'm not going to threaten General Motors with attorney's fees, but I am going to tell you that there is no basis in the law for you to instruct this witness not to answer a question other than privilege. And you know that's the law of the state of Florida, and so do I. So for you to instruct him because you think he's being badgered is not appropriate legal objection. And the judge is going to permit me to come back and complete this deposition. So I would suggest, since Mr. Ivey doesn't really even want to be here in the first place, and that he does want to get it done in one setting, that you let him answer the questions. That's all I'm going to say. If you want to instruct him not to answer, you do so at your own peril. He will come back here, or, like you said, the judge will assess attorney's fees and costs against General Motors. They don't really care anyway, but that's neither here nor there. So my question is, I asked you earlier, sir, you just actually said for the first time, you don't know why you wrote the document, do you?
Yes.
Which document?
The value analysis document. You don't know why you wrote it.
I do not know why I wrote it. Yes.
Okay. You don't know who asked you to write it, or why you wrote it. That's your testimony, isn't it?
Asked and answered, repetitive.
I do not know why I wrote it. I don't remember anyone asking me to write it, and I don't believe anyone did.
Okay. That's what I call total memory failure. Do you agree with that? That you just don't remember any of that stuff
Objection.
about this document?
Argumentative and repetitive.
I believe it's insulting to say I have total memory failure, and I don't believe that I do.
Don't you think it's insulting to a jury for you, sir, to come in and tell them that you don't remember who told you to do it or why you did it? Don't you think that's insulting?
I've told you that I...
Hold it. Argumentative, objection to the form. I'm sorry to interrupt you, but I've just got to get my objections in there because that's what the rules say. So,
I don't believe anyone asked me to write this document.
Okay, and you didn't believe until I showed you your affidavit that it had anything to do with rear impacts, did you?
objection, argumentative, and repetitive.
All I can say is this analysis makes no mention of rear impacts.
But your affidavit says that it was related to your rear impact studies, doesn't it?
Argumentative and repetitive.
It says that it's related to rear impacts.
Right. So then we know that the truth of the matter is, even though your memory doesn't serve you here today, that when you filed this affidavit, that the truth was that the value analysis report is related to your study of rear impact collisions of passenger cars.
Argumentative,
True?
Argumentative and repetitive.
I've said innumerable times. I don't remember.
Okay. I know you've said innumerable times you don't remember.
Motion to strike a comment.
Now, in order to prepare that value analysis memorandum, you relied upon the academic studies that have been given to you by General Motors corporate staff at the Tech Center, correct?
Yes.
And you don't recall the names of the people who gave you those studies, do you?
Asked and answered and repetitive.
No, I do not.
And you don't recall the names of any of the studies that you used, do you?
Asked and answered, repetitive.
I do recall basically, as best I recall, where they came from.
Well, do you remember being asked the very first time your deposition was taken, closest in time to the time that you discovered that that memorandum surfaced, that you didn't recall the names of any of the studies that you used to prepare that value analysis report?
Objection, improper impeachment.
I don't remember what I said in the first deposition.
Well, the first deposition was taken in the Burton case. That's the very first deposition taken on September 18th, 1984, after this memorandum, after this report, or whatever we want to call it, appeared for the first time. Do you remember that was the first deposition you gave?
Yes.
Okay. And at that time, the lawyer who was taking your deposition asked you specifically if you remembered the names of the studies that you relied on that were given to you by corporate staff. Do you remember him asking you those questions?
No, I don't.
Would that have been the first time those questions would have ever been asked of you?
Objection, vague and ambiguous.
First time. No, they probably weren't.